Madras Chamber, sir, is a young 184-old chamber, which is the second oldest chamber of the country. The Arbitration Center also of the Madras Chamber is in its 20th year, but it's been a low-key affair till now, and only this month we plan to move into a space for the center on its own. Till now, it was sharing its space with the chamber itself. So we are going to have our exclusive arbitration center coming up in the next 2 weeks. We would be having our opening ceremony, 21st or 28th, in fact. And as part of the revamp, I would say, of the arbitration center, we have formed a governing council where Mr. Anirudh and Vaitishwaran are also part of it. And as part of the same arbitration governing council's initiative is this lecture series on, web series rather, I should say, on arbitration on different aspects. This is the 4th month. We hope to continue this for a future as well. With that, sir, thank you very much for joining us, and it's really indeed a pleasure to have you. With that, I would request Anirudh to take on from here.
Thank you, Mr. Anand. Our guest speaker for today needs no introduction in the field of arbitration. Justice Sundar is the author of a number of jurisprudence defining judgments in the field of arbitration, whether it was the judgment in lifestyle equities on the arbitrability of intellectual property rights, or Kaupath Builders, which was perhaps the first judgment on the restrictive scope of Section 34 post-amendment, or the recent judgment in 14 reels on what amounts to reappreciation of revenue, been amongst the leaders to sort of set out what the position of law is under the amended Arbitration and Conciliation Act. We welcome you, sir. It's a huge honor for us that you've accepted our invitation to be a speaker in today's panel. We look forward to hearing from you on the march of law in relation to Section 34, considering that you have been an integral part of laying down the law in this area. Thank you, sir, and over to you. Sir, I think you're on mute.
Thank you, Mr. Anirudh. Thank you. I would request some of you to be on the screen so that I would request some of you to be on the screen. Otherwise, I would virtually be. This is like lawyers insisting that I need to see the judge's facial expression while I argue. So therefore, I should at least know when to stop. So for that, probably Mr. Anand Gopalan can also come on screen, or anybody else besides Mr. Vaitishwaran, and I find Madam Saraswati on the screen. You can come on. As long as the bandwidth is not a problem. As long as the bandwidth is not a problem.
Yeah, we are all. Our videos are on Anirudh.
Yes, you're all visible. At least 4 of you are visible now.
No, because it's the webinar part of Zoom. Only the panelists would be visible to you, not the speakers. So.
Oh, that's right. At least the panelists I would like to see.
We are there.
We remain. Yeah.
Good evening. I'll start with a formal address. The Governing Council of Madras Chamber of Commerce and Industry Arbitration, Mediation and Conciliation Center, right? That's what MCCI stands for. MCCI, that's the expansion I could see. Madam Saraswati, Mr. Vaitishwaran, Mr. Anand Gopalan, Mr. Anirudh Krishnan, and all others who have joined the meeting today. Good evening. At the outset, my apologies for skipping the webinar on 8th, I think 8th October, if my memory serves me right. Please accept my apologies. That was something completely unavoidable and inevitable. Therefore, I had to skip that. And you all heard Mr. Anand Gopalan say we are a young entity. Now I'm sure, I don't know how many lawyers are there amongst the audience. Now you know why lawyers are those who argue white is black and black is white. So when they say it's a short matter and it would take only 10 minutes, I ask them how many hours make a minute. The conversion is also possible, though it will be in decimals. So this much with regard to the introductory note. And I think your governing council member, Mr. Anirudh, was constantly in touch with my peers. And he was so constantly in touch with my peers that I had to tell him, I thought you were persuasive only in court. So that was it, and that's how I'm here. And so you all have to bear with me for the next 40 minutes. Now the topic is some enigmas and issues, enigmatic issues and unique principles pertaining to scope of Section 34. And Mr. Anirudh also mentioned you're looking forward to my take on the march of law. So then we will start with the march of law, QA 34. Now, what would be the equivalent of 34 under the 1940 Act? If you look at what is the equivalent to Section 30, a very interesting scenario unfurls. Before I tell you what the interesting scenario is, what you have to bear in mind is the scope of challenge to an arbitral award has been made extremely narrow over the years across the statutes and across two major amendments to the present statute, namely one in 2015, 2310-2015 to be precise, and the other on 30th of August 2019 to be precise, namely Act 3 of 2016 and Act 33 of 2030 or 33 of 2019. Oh, it's become narrow. That's the long and short of it. Now, this 1940 Act, Arbitration Act, was in vogue from 11th of March 1940 to 22nd of August 1996, when the present Act kicked in. Let's look at, now we say it's become narrow. Let's have a quick look at Section 30 of the 1940 Act. Section 30 of the 1940 Act says, it's captioned grounds for setting aside award. It says, an award shall not be set aside. A negative connotation shall not be set aside except on one or more of the following grounds. Let's see what it reads under 34 of the present Act. It says an arbitral award may be set aside only if is the addition. We started with a negative connotation, statutory negative connotation in 1940, which was in vogue till August of 1996, and now in 34 says may be set aside, but only if the 8 slots are there. I don't call them grounds because 34 is not an appeal. I have written that these 8 slots are 8 pigeonholes. 5 under 34(2)(a), 2 under 34(2)(b), and 34(2)(A) is one slot by itself. So unless you fit it into any one of these slots, you don't succeed in dislodging an award. This is the obtaining position of law with regard to 34. Now, another interesting aspect is, now from a negative connotation of shall not be set aside except on one or more of the following grounds, to may be set aside by the court only if there are two provisions which are of relevance, namely sections 5 and 35, which are relatable to what we are looking at now. Section 5 and 35 of the present Act. 5 talks about minimum judicial intervention, and 35 talks about finality of arbitral awards. Now, if you look at equivalence, there is no equivalent of Section 5 under the old Act, for sure. Now, if you look at, if there is an equivalent to Section 35, the equivalent at best to my reading is Rule 7 of Schedule 1 of the 1940 Act. Now, Section 5, therefore, of the present Act is a new provision that talks about minimum judicial intervention, and Section 5 says, notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, meaning part 1 and meaning sections 1 to sections 43. Sections 1 to 43 constitute part 1. No judicial authority shall intervene except where so provided in this part, so provided under 34. Now, that is also in part 1. 35 is finality of the arbitral awards. That's ingrained in 35. That would say, subject to this part, part 1, arbitral award shall be final and binding on the parties and persons claiming under them, respectively. Now, let's look at Rule 7 of Schedule 1 of the 1940 Act. That says, the award shall be final and binding on the parties and persons claiming under them, respectively. So, therefore, minimum judicial intervention, finality of the arbitral award which has been carried through, and except as provided under this part, namely Section 34, is the new addition, is as I read it. And this is how we see the metamorphosis from a negative statutory connotation of shall not be set aside except under any one or more of the following grounds to may be set aside where only on the following grounds. This much about the metamorphosis, if I may say so, with regard to challenge to arbitral awards under Section 34. Now, with regard to the march of law, we'll just quickly go through that little later meaning maybe 10 minutes into this. I would like to share with you another interesting aspect of a challenge to, whether you call it an enigma or whether you call it interesting, I leave it to your imagination. One aspect I would share before we go to the further march of law. Subsection 3 of Section 34 is of enormous importance, great significance. I am told the audience have a working knowledge of arbitration and challenge to arbitral awards, right? That's what I was told. So therefore, I am proceeding on that basis. I am not getting into the fundamentals or first principles. Likewise, I am not getting into the esoteric terrain of the jurisprudence either. Therefore, I would be on the working principle. Subsection 3, in sum and substance, provides for the timeline within which challenge to an award should be laid. Before we read it, broadly it is like this. It should be challenged within 3 months from the date of receipt of the award, and whenever there is a correction to the award under Section 33, from the date of the correction. 3 months. Then there is a proviso to subsection 3, which says delay post 3 months is condonable, but not exceeding 30 days. There is a cap. If you look at it, subsection 3 and the proviso effectively talk about a limitation for the period of limitation or prescribed period of limitation, to put it statutorily, for filing an application under section 34 to challenge an award, and a cap up to which the delay is condonable. But two different measures are used in the provision and the proviso. Proviso is in months, proviso is in number of days. Please take it from me, because of this 3 months and 30 days, many would say 120 days. Take it from me, this is incorrect. It is not 120 days. The provision and the proviso are in two different units or two different measures, namely months and days. 1 month may or may not be 30 days. This is the law. 1 month is not always 30 days. 1 month may be 28, 29, 30 or 31 days. Any one of these four, depending on whether you're on a leap year or not. Then how do you compute this 3 months? It's very interesting. The law on the point was laid down in Himachal Techno with regard to how you compute. I would give the case law. Himachal Techno. I'll just give the case law and then probably you can that is 2010 12 SCC page 210. Himachal Techno says the date of receipt of award should be excluded. Please bear this in mind. So assuming the date of receipt of award is 5th of November, then you exclude 5th of November and start computing from 6th of November. Then when does the 3 months elapse? Then you start from 6th of November, December, January, February. It would be 6th of February. The reason is 1 month is explained as the corresponding date in the next calendar month. This you will get in Bibi Salma Khatun's case, 2001, 7 SCC, page 197. Now, what can happen is there may not be a corresponding date in the next month. Assuming it is, say, 29th of January or say 30th of January, forget 29th, 30th of January. There may be, and if you're computing 1 month, there may be no corresponding 30th in February. Then which would be the corresponding day in the next month? The last day of that month. Simple. Be it 28 or 29, whether it is a leap year or not. The lead case law on this, which has been followed by Supreme Court in Bibi Salma Khatun, is an English case law, Dodds versus Walker, House of Lords, 1981 judgment, 18th of June, 1981. And you would get it in Halsbury's also. It's Dodds versus Walker. I can try and give you the English citation also, House of Lords. So this is where the law stands. And then 30 days, after elapsing of 3 months, you start calculating the 30 days. So therefore, please bear in mind that the prescribed period of limitation and the condonable limit or the tolerance limit are in two different units, namely month and days, and a month is computed in the manner which I have shared with you. Now, I wouldn't say explain, I do not want to say explain, in the manner in which I have shared with you. A number of days is, of course, you can go by the numeric count. This is how, so therefore, many matters, this kind of difficulty arises. So please bear this in mind. The reason why I thought it fit to spend some time on the subsection 3 is the Supreme Court has held, and I have also repeatedly held, that even 1 day's delay beyond 30 days is not condonable. Therefore, if you file it on the 31st day, post 3 months elapse, post 3 months elapsing, you're out. Therefore, even 1 day's delay is not condonable, because the expression "not thereafter" is used. The general principle all of us are aware is, moment a special statute provides a special period of limitation, Section 5 of the Limitation Act is not applied, not applicable. So therefore, you can't invoke Section 5 of the Limitation Act. More important is, in Section 34, you will find an expression "not thereafter," 34(3). I'll quickly read through. An application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award. Himachal says exclude the date. Please bear that in mind. Or if a request can be made under Section 33 from the date on which that request had been disposed of by the arbitral tribunal, which I told you, provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the set period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter. This "but not thereafter" was explained by Supreme Court in Simplex Infrastructure. That is, Simplex Infrastructure is 2019 2 SCC, page 455. This is where you get the proposition that even 1 day's delay beyond 30 days is not condonable. And you know, limitation, the principle is the right does not get extinguished, but the remedy gets barred. At the end of the day, what is the difference to somebody who wants to lay a challenge? The legal principle is the right does not get extinguished, the remedy gets barred. Agreed. But for a protagonist under 34, for somebody who wants to assail an award under 34, what difference does it make? 1 day can make all the difference between your right to challenge the award and you losing it. So please bear this in mind. Then quickly, we will go to another aspect of the matter, that is regarding whether under 34 you can ask for modification of an award. That's according to me, it still remains, to my mind, a conundrum. To my mind, I would say it remains a conundrum. The reason is, the Supreme Court in McDermott said, once an award is set aside, the re-arbitration is the only remedy, and there is no other remedy. And in paragraph 52, subject to correction, it is also explained that you either set aside or sustain the award. This would be, one moment, I will give you the McDermott is 2006, 11 SCC, page 181. I would request Mr. Anirudh and Mr. Anand Gopalan to correct me if I'm just getting any of these citations wrong. I'm just trying to, don't hesitate to. Don't hesitate to tell me the numbers, the page numbers also. Then, of course, in some cases, modification of the award has been sustained with regard to interest, and those judgments would be, but those are not judgments where the question of whether modification is permissible was gone into. That would be Hindustan Zinc 2006 4 SCC 445 and Numaligarh Refinery 2007 8 SCC 466. More interestingly, in the recent Sangyong, what I could read was, though it did not go into that question as much as what I could see, Sangyong is 2019 15 SCC, page 131. Paragraph 77, Supreme Court says, under the scheme of Section 34 of the 1996 Act, disputes decided by majority award have to be referred afresh to another arbitration. Ultimately, they did not do that. They took the 142 route and sustained the minority award. I'm just going to deal with that next quickly. But the point is, under the scheme of Section 34, it has to be referred afresh. That is what the Supreme Court says. Therefore, what could be inferred is modification is a gray area, read in context of McDermott, but then interest modification has been sustained, and that is the reason why, to my mind, it still remains a bit of a conundrum, and maybe it will get settled in the days to come. Now, more importantly, while on Sangyong, I thought I would also share this with you. As all of you, I think somebody is putting up something on the chat box. I would take the questions to the extent possible as soon as I complete. Now, arbitral tribunal should consist of odd number of arbitrators, which all of us are aware of. So therefore, a tie is not possible. But you may always have a dissent. Now, in Sangyong, it was typically a 2:1 award. Normally, when an award made by an arbitral tribunal constituted by more than one arbitrator, when there is a minority view, court exercising power under 34 would only look at the award before it as a 2:1 award, or a 3:2 award, or a 4:1 award, and test that award. A Section 34 court would not go into whether which view is correct or which view is more acceptable. That would not be the role of a Section 34 court, in my limited understanding. But in Sangyong, what the Honorable Supreme Court did was, Article 142 power was exercised. That is to do complete justice between the parties. That's an exclusive power vested with the Honorable Supreme Court. Supreme Court said, if it is sent for re-arbitration, the majority award, that is again going to be time consuming. It's a question of application of formula. Therefore, by applying Article 142, we would sustain the minority award and say minority award would now become the award. But please bear in mind, that is an exercise of Article 142, which is an exclusive power vested with the Honorable Supreme Court, and not an exercise of power under 34 of the Arbitration and Conciliation Act. This is my understanding of 34. Then we will quickly look at the march of law, and then my take on what would be the scope of 34, and I will end with that. The march of law quickly is like this. 1940 Act was in vogue from 11/3/1940. And if you see the section 30, which we just read now, there is no public policy ground for setting aside for setting aside an award. The first time that was brought in was in Renu Sagar. Renu Sagar is 1994 Supplementary 1 SEC, page 644. The date of the judgment is 7/10/1993. But please bear in mind that in Renu Sagar, the court was dealing with section 71B2 of the Foreign Awards Regulation and Enforcement Act 1961. Please bear that in mind. That was the first time public policy came in. I'm not going into that in great detail. Thereafter, we had the 1996 Act that kicked in on 22/8/1996. When it came into force on 22/8/1996, public policy became one of the slots, and that was under 34(2)(b)(2). Under 34(2)(b)(2), contravention and award being in contravention of public policy became a ground. There was an explanation also. That explanation was restricted to the award being in contravention with 75 and 81. Which is now clause 1 of explanation 1. Thereafter, on and from 23/10/2015, an amendment was made and two explanations were brought in, explanations 1 and 2. This explanation, which was originally there, was retained 75/81, but that became clause 1, and two others, contravention with fundamental policy of Indian law and conflict with most basic notions of morality or justice. More important is explanation 2. For avoidance of doubt, the test as to whether there is a contravention with fundamental policy of Indian law shall not entail a review on the merits of the dispute. Please bear this in mind. How this explanation 2, and of course explanation to 2A, patent illegality, came in. We'll just see as we see the march of law. After this act kicked in 1996, the next major turn was saw pipes. That was on 17/4/2003. I'm taking you through chronologically. I just quickly jumped to 23/10/2015 because while I was on the explanation, I thought I should share it with you. After 22/8/1996, chronologically, the next was saw pipes, 17/4/2003. The citation is 2003, 5 SCC 705. The significance of saw pipes is when the new Act 1996 Act came in, patent illegality was not a slot. 2A was not there statutorily available, but it was added as a ground, added as one of the slots of challenge by saw pipes. I remind myself that then 2A was not there. 2A came in only on and from 23/10/2015. Please bear that in mind. Then came the 246th Law Commission report that was submitted on 5th of August 2014. It was submitted on 5th of August 2014. After the 246th Law Commission report, there were two significant judgments, namely Western Geco and Associate Builders. Western Geco is dated 4/9/2014. The case law is 2014 9 SCC 263. Associate Builders, those of you who would like to have a list of this case laws, I think I would request Mr. Anirudh to share it, because I'm sure you have all these case laws which I'm talking about. If somebody has missed noting, because I couldn't make a PPT, pardon me for that. I really wanted to make a PPT. I couldn't make a PPT. I was running out of time. So I couldn't make a PPT in that sense. So all these citations, if somebody wants, you can share the case laws. Associate Builders was on 25/11/2014 and the citation is 2016-3 SEC, page 49. Owing to these two judgments, a supplementary report, a supplementary to the 246th Law Commission report came to be submitted or given, I won't say submitted, I would say given by the Law Commission under cover of a letter of the chairman of Law Commission. It is all there in domain, public domain, dated 6th of February 2015. There, this explanation 2 and proviso to 2 capital A was suggested, saying public policy is becoming very, very expansive. It can't be this expansive. Let it be statutorily made clear that there shall be no review on merits, and that on patent illegality, mere erroneous statement of law will not become a ground for patent illegality, and reappreciation of evidence is impermissible. Let's quickly see these two provisos. Explanation 2. This is explanation 2 to 34(2)(b)(2), public policy. It says, which I read now, for the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Then 2 capital A talks about patent illegality. I'm skipping that. I'm going to proviso to 2 capital A. Proviso says, provided that an arbitral award shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. Now, if you ask what is patent illegality, then the question may be, the answer may be ignoring vital evidence, looking into evidence received behind the back of a party, or rendering a finding on no evidence. Broadly, maybe patent illegality, but then reappreciation of evidence is impermissible. I have made an attempt to explain all this and say what is the appreciation of evidence and what is the reappreciation of evidence. That is in that 14 Reels case, which Mr. Anirudh mentioned. I'm not reading the Law Commission report, letter, all that. May not be. It's all available in public domain. Just give me a minute and the 14 Reels I would. Here it is. No, I don't think I have 14 Reels. I'll ask Mr. Anirudh to give you the. Can you give the citation? It's not reported. I think you can give the. There I have attempted to explain what is this appreciation of evidence, and once you have clarity and specificity on what is appreciation of evidence, then you go on to reappreciation of evidence. This is one aspect of the matter. Then let's continue with the chronology. So because of the supplementary report, this Act 33 of 2016 kicked in, 23/10/2015. All this was brought in, explanation 2, all this was brought in. And then came the Sanyong judgment, which I was referring to. 8/5/2019, the citation is 2019, 15 SEC 131. If you see Sanyong would explain how this 23/10/2015 has impacted the law laid down in Western G-Co and Associate Builders. It is clarified, it is made clear what survives, what doesn't. For instance, NJP would survive, and then for instance, perversity as understood in Associate Builders may now not be available as perversity, but will be available as patent illegality. These are all post-Sanyong scenario. Now, therefore, you will have to look at SsangYong and this provision. And what is not available also has been made clear in SsangYong. I may not bore you with the paragraphs and take you through all that. Suffice to say that because it doesn't entail a review on the merits of the matter, paragraphs 28 and 29 of Associate Builders, which extracts 35 and 38 to 40 of Western GCO, may no longer be relevant. That's what SsangYong says. This is in para 36 of SsangYong. And then if you go to paragraph 36, it says NJP is still available. No difficulty about that. And then in paragraph 41 of SsangYong, it would say, Associate Builders has explained perversity in paragraphs 31 and 32 in a particular manner, 31 and 32 of Associate Builders. That may now not be available as perversity, but will be available as patent illegality. You may ask me, what is the difference? It's nonetheless available as a ground, is what you may ask me. It is. But mind you, the moment you say patent illegality, it is circumscribed by the two-limbed proviso. Mere erroneous application of law 1 and 2, this reappreciation of evidence being forbidden. This two-limbed proviso will operate if it is patent illegality. So this is broadly the march of law as far as I could see. I think I have given all the most significant dates and events. Maybe another 3-4 minutes on one more point, and before I wind up.
Sure. This
One other what I wanted to. Now I'll complete with this. What I will do is I'll complete with this. Now this we saw 34. We saw the march of law from 1940 to date. We also saw some issues pertaining to limitation. And there's another on third party invoking 34. I don't want to go into it now. This 34, when you challenge an award, please bear in mind, is not an appeal. It is not akin to section 96 of the Code of Civil Procedure. It is not even akin to section 100 of the Code of Civil Procedure. It is neither a first appeal, which is still a court of fact, not even a second appeal under 100, where it turns merely on a question of law. Not an appeal. Is it a revision? No. Is it a review? I would say, and I have said, it is not a full-fledged judicial review. Then what at all is this 34? It is not an appeal. It is not a revision. It is not a full-fledged judicial review. I would say it is just a challenge to an award within the contours and confines or within the legal perimeter or statutory perimeter of 34. Within the legal landscape of 34, namely the 8 pigeonholes and some of the principles explained by courts. So when you challenge an award, if you are able to fit it into one or more of these pigeonholes, you dislodge the award. If you don't, you cannot. Therefore, not an appeal, not a revision, not a review. A mere challenge to an award within the legal landscape and statutory perimeter of section 34 of the Arbitration and Conciliation Act. And more importantly, the Supreme Court also says this 34 is a summary procedure. Please bear that in mind. It is a one-issue summary procedure. When you say a one-issue summary procedure, sometimes there is scope for some ambiguity. People do think that it is one issue where the dispute before the arbitral tribunal. No, let's have clarity. Let's have clarity and specificity on that. When the Supreme Court says it is a one-issue summary procedure, the award being put to challenge itself is an issue. And that is the issue, one issue. This is what the Supreme Court says in FISA developers. I'll just quickly give you the case law on that. FISA developers would be FISA developers is 2009 17 SEC, page 796. The most relevant paragraph would be paragraph 24. I'm not reading it. I'll just quickly read it. It's a small paragraph. In other words, an application under section 34 of the Act is a single issue proceeding where the very fact that the application has been instituted under that particular provision declares the issue involved. Any further exercise to frame issues will only delay the proceedings. It is thus clear that issues need not be framed in applications under section 34 of the Act. It also says it's a summary procedure. This was reiterated subsequently in MK Global 2018. 2018, 9 SEC, page 49. Relevant paragraph is paragraph 21. While reiterating FISA developers, I'm not reading it. It's a slightly long paragraph. What the Honorable Supreme Court said was FISA developers is a step in the right direction where the objectives of the obtaining Act. This is the long and short of it. And finally, as late as 2019 in Canara Nidhi. Canara Nidhi is 2019, 9 SEC, page 462. Here, FISA developers and MK Global were reiterated. More importantly, in paragraphs 18 to 20, what the Supreme Court said was, you cannot introduce any new document, effectively not a shred of paper, which was not before the arbitral tribunal, without the leave of the court. Extraordinary circumstances where post-award, assuming for a moment if it's a post-award corruption issue or post-award you say something has transpired, it's come to light, and therefore there was some disclosure was not made, and therefore you want to bring on board some document. This is just illustrative. I'm not giving you anything that is exhaustive. But the point is, no shred of paper can be introduced in a section 34 if it was not before the arbitral tribunal. And section 34 is a one-issue summary procedure. No question of framing issues, no question of letting in evidence. And lastly, as I mentioned, no question of introducing new documents and arguing the matter. In effect, there is no equivalent of Order 41, Rule 27 of the CPC. It's a complete departure. Order 41, Rule 27 of CPC deals with additional documents in an appeal. You can bring in additional evidence in an appeal. Impermissible under 34. This is the narrow scope. I think broadly, I was able to tell you about institution of a 34, limitation, the scope, the march of law, and the obtaining position when you go to court challenging 34. I think I'll stop with that. I think I've exceeded my time. I've gone on for 50 minutes, 50 minutes. So I'll stop with that. Thanks for the opportunity. Thanks for
Thank you very much, sir, for the highly educative talk. We've all benefited immensely. When Mr. Anand Gopalan requested me to be the moderator for today, the first thing that occurred to me is that usually it is Justice Sundar who asks us the questions, and as lawyers, we need to go back and work. So I welcomed a role reversal today as the moderator. So
Hope you have not circulated some questions to the participants.
before I go to the participants' questions,
Yes.
I have one question.
Yes.
I would request you to take your judicial hat off and wear a legislative hat on. As a person who interprets Section 34 day in and day out, are there any legislative changes that you would like to recommend to the text of Section 34 as it stands today?
Ideally, I would like to say well left, because of where I'm sitting.
Yes, sir.
It would be it would be
yes, sir.
ideal. It's quite a juicy half volley, but
Yes,
ideally, I would earn a well left.
I understand, sir.
It may not be appropriate for me to. The law is there. I'm interpreting the law. I'm implementing the law. Unless it becomes absolutely imperative, you don't recommend.
Yes. Yes.
Recommend any legislation. Therefore,
yes.
Sitting within courts, I think it may not be in a public forum for me to get into that. Yes, please.
We have a question from Mr. Mohan SL. The question is, can a district court assume more powers than the High Court while deciding an application under Section 34?
Can a district court? Can you say that again, please?
Yes. Can a district court assume more powers than the High Court while deciding applications under Section 34?
No. I think it's no. But I would like to know what prompted him to ask that question. That may throw more light on. That may help me try and answer.
Is there any way we can?
He's been unmuted. Mr. Mohan, you have been unmuted. Kindly ask the question.
Mr. Mohan?
All right, we'll move on to but the answer is a simple no. But if I know what prompted him or what impelled him to ask that question, I thought I may be able to explain a little more. Yes, please.
Are there any questions from the other panelists?
Your Lordship, I have one question. Your thoughts on the subsequent decision of the Supreme Court in that CMAC engineering?
CMAC?
Yeah, Southeast Asia Marine Engineering.
Yes.
Your thoughts on that in the context of what you had spoken about matters of law?
Subject to correction, Southeast Asia Marine, I think, reiterates the position.
Reiterates the position, and they looked at whether the non-reading of the entire contract clauses by the arbitrator of the tribunal would be a ground for a challenge, and held so. So in the context of the appreciation of evidence point and in the context of...
No, appreciation of evidence may be an entirely different realm in comparison to the covenants in a contract. As far as the covenants in a contract, how a commercial contract has to be looked at, the lead case law is Nabha Power. Nabha Power lays down after a survey of the law across an international scenario. It lays down how a commercial contract, because the commercial sense is there while the parties make the contract. Lot of thinking goes into it. For example, I'll just give you an illustration. Suppose parties agree on liquidated damages, say between a particular percentage X to Y, between X and Y of the value of the contract, percentage X to percentage Y of the value of the contract, then it may not be for the tribunal to say that Y is onerous.
Right.
The parties have hammered it out, they have discussed. It may come across as onerous to the court, but then while interpreting a commercial contract, the parties have agreed. So in that given case, whether it would be X or X plus N1 or X plus N2 or X plus N3, as long as it doesn't exceed Y, that would be your batting width. That's my understanding.
Got it.
There's a question from Dr. Shrikant Parthasarathi. He says, wonderful presentation. Does Section 34 lay down a procedural framework for challenge? If a private institution, the arbitral tribunal, private institution, I think he refers to an arbitral institution, has a different internal procedure, can the procedure itself be challenged, or Section 34 provides for challenge of specific award only?
I think the question is in three parts. I'll answer it in three parts. Part one, many thanks. Thank you. Part two, the procedure, if any, should be laid down by the High Court by its rulemaking power under 82. 82 of the Act provides for the High Court to make rules to regulate the proceedings under the Act, which will include 34. Many High Courts have done it. We are in the process of doing it. It's in the annual. So therefore, procedure is that made by the High Court under 82. And lastly, with regard to the procedure of institutional arbitration, by party autonomy, if you have agreed for institutional arbitration, I'm afraid you cannot challenge it. And definitely not under 34.
Thank you, my lord. There's one more question. We don't know the name of who asked this. Does equity have any role in relation to challenge of an arbitral award?
By the arbitral tribunal or
challenge under Section 34?
The answer would be you have to go by the law. The arbitral tribunal can do that, but then there is a specific provision for that 28. Because I don't know, that's why I wanted to know whether you were asking about 28.2. 28.2. So there, that is only if the parties agree. That is only if the parties agree. Amiable compositor.
Yes.
Yes.
Thank you, my lord, for answering all these questions. I would now pass it on to Vaidishwaran sir for the vote of thanks.
Thank you, Ani, and thank you, my lord. And it was like going back to college days. I don't know whether his lordship would recollect my face. I was 1 year junior to him.
I'm sorry.
Yeah, I was part of Lordship Sindhil Kumar's batch, just to Sindhil Kumar.
No, that was not 1 year junior. Then it should have been
2 years.
2 years junior.
2 years junior. And so I've listened so often to Justice Sundar, and it's actually a lot of people are missing this. What we used to hear in college are now hearing in this form of a web series. I was also I attended your MBA session on this topic, and it was brilliant. And I'm so glad that you could spare time and come to Madras Chamber for this particular event. And it's definitely a treat, the way you took across right from 1940 comparison to the current provisions, and took us through every single decision in its appropriate flow. And I would say that when you talked about this 3 months issue and the days, you talked about those specific case laws in the context of day and months. It is very important for many of the younger professionals to understand this, because as a lawyer's office, the biggest challenge is the juniors filing the appeals in time. Because I come from a tax background, and we have a similar provision in tribunal, where the appeal lies within 3 months to the tribunal, whereas the first appeal lies in 60 days. So I always have this interesting debate as to please understand months and days difference. And it was so nice that you could bring it out so well in the context of Section 34. And it is more relevant that we chose this topic for our discussion, and we chose the caliber of this kind of senior most judge to hear and share his knowledge and thoughts. And the march of law, as Anirudh lightly put it, is still going on. Yesterday, there is an ordinance which has come, which has amended the Arbitration Act and brought changes to Section 36(2) and retrospectively. And the age schedule has been deleted, and rules are going to come. So the march of law seems to continue. And in that context, I think the chamber was completely lucky to get hold of you. And thanks once again from the bottom of my heart for sparing your valuable time and sharing so much of knowledge. Thank you so much.
Thank you. Thank you. I will take leave. I'll take leave. Thank you.
Thank you.
Thanks, sir. Thank you, sir. Thanks, Anirudh, particularly.
Thank you.
And Anand.
Thank you.
So,